All right, let's get started here. Thanks for joining me today. My name's Anthony DeBello. I'm the Senior Director of Market Development for OpenText. And we're going to talk a little bit about GDPR in this session. And interestingly, I noticed just next door there was a cross-border forensic session. In this session, we're going to speak a little bit more broadly. Search and collection needs pertain to forensic, e-discovery, security. Spent a lot of time out in Europe talking to some of our customers out there and some of their needs as it relates to GDPR and some of their concerns, which in our business there's certainly quite a bit of concern, and this extends beyond just searching and collecting data, but how data is stored, transmitted, how systems manage information, and we'll talk a little bit about that today. But first, I'm going to talk a little bit about GDPR in general, as well as the results of a survey we conducted earlier this year with about 400 companies regarding their plans, their readiness, and give you an idea of what some others are thinking out there. A little bit of a spoiler alert, it's not that great. Come May of next year, who's going to be compliant? Probably not many folks. Will people even be ready or start thinking about it? We'll see. I suspect similar to how PCI compliance came into effect, we'll see the same thing with GDPR. It's going to be that first fine that sets off the cottage industry supporting GDPR compliance as well, as soon as people figure out exactly how to interpret the letter of GDPR. Before I get started, how many folks have read the regulation? Cool, good. That's the first step. And if you have read the regulation, you know it's not entirely prescriptive in terms of how to implement controls, systems, people, processes. Well, specific on people, appointed data protection officer. Well, what are they supposed to do? That too is open for interpretation based on reading the regulation. But you know, the last time a change like this happened, just looking at the quote up on the screen, it's been quite some time. It's been 20 plus years since we've seen such a change in data regulation. And you know, a lot of folks are still trying to figure out what to make of it and what course to take as it relates to their own GDPR compliance measures. There's a good reason for this. It's not necessarily about privacy, though certainly that's the lens with which the regulation's being viewed, how folks internal to corporations and others are looking at the regulation. But you know, looking at some of these stats related to the hacks and breaches, data compromises that have been going on over the past many years, it's really about trust. It's really about the European citizens' ability to trust corporations handling their information responsibly, which today, you know, how many of us can say we really believe any corporate entity is handling the data we give them in a responsible manner? But now, GDPR may not be the perfect answer, but it is an answer. It's going to apply to us all, at least any of us that do business with European citizens. And we need to start building that framework within our organizations to come into compliance. Our research shows with consumers, the vast majority of those don't trust corporations with their data. And this is even more obvious in Europe and the cultural differences in how we look at data. If in Europe, the data that relates to you is your data, in the US, data's free. Advertisers and others seem to, you know, be able to do what they wish. The regulatory environment's certainly not as strict. But again, this is starting to affect the US as well as, again, any other company in the world that tries to do business with European citizens. So we know this is going to take effect next year. It impacts us all. And what's going to be most interesting is who that first fine is going to be levied against. We can all take bets. I suspect it's going to be a U.S. media company that may be one of the first, or advertising company. The EU has shown they're not afraid to go after the likes of Google's, Amazon, others given, I'm sure, their regulatory belief that U.S. companies are coming at data privacy and security from a very U.S.-centric point of view, and will be looking to make a point. And at that point, we'll see certainly the industry take note, presumably, and move a little bit more seriously to GDPR. And we'll see through our research what the preparedness state really is. And as we're going through this, think about your own plans, your own readiness, and some of the things you're thinking about doing internal to your own organizations or with your clients, if you're a law firm or service provider, as it relates to GDPR. So, first question that we asked was, where are companies in their overall planning? You know, the vast majority, over 50%, either don't have a timetable or will likely not be compliant and aren't afraid to admit it right now. A minority are in various phases of planning. Some have begun rollout, very small percentage, about 7.5% have started to roll out policies, procedures, people, whatever have you, technology to help manage some of the requirements or presumed requirements of GDPR. But again, from what we saw, if you dive into the research, most of those companies are European companies, and if you're familiar with the privacy environment, particularly in France and Germany, they've already got a regulatory framework that in some ways are more stringent than GDPR. It's really UK, other countries in Europe, and the US that are really just starting to think about it. I was having GDPR-related conversations in Europe probably 18 plus months ago. Those conversations really didn't start here in the US till earlier this year, and that really was only with the financials in New York that have started to give this a little bit more thought than others, at least at an aggregate level. And then to be compliant. Again, this is about interpretation. Folks are trying to figure out what do they need to do in order to become compliant. Some are doing or looking to do a full audit of personal data. That's a huge task. I've been doing kind of data protection, GDPR talk. Something I ask audiences is, you know, who knows where all the sensitive data is in your own organization? It's everywhere. But in terms of where exactly, that's a harder question. How's it getting used? Who owns that data? Who's responsible for the data? Who should or shouldn't have that information? We have it, but if you look to something like the right to be forgotten, are we ready to target it, eliminate it, and prove to a requesting citizen that that, in fact, was done with any degree of certainty? Some are going as far as starting to evaluate their third-party service providers, which is another element that needs to be considered, data transfer between partners. Some are changing their cloud providers. We're clearly seeing more and more vendors, just looking at some of the announcements Relativity made this week, opening data centers in Europe, in Asia, other places to start complying at least with some of the cross-border data flow mandates that exist within GDPR. Now, I think one of the more interesting ones on here, and this is the head in the sand response, divest EU operations 11.9%. That tells me that there's a slice of folks that really don't understand the nature of GDPR and to whom that complies just by divesting your office in Europe. No, that means you need to cut off all business with Europe and European citizens if you want to avoid any compliance requirements that exist inside the regulation. Some using binding corporate rules. That's a more straightforward approach, seeing that really more of a topic in Canada as an example than the US in terms of approaches they're looking at in order to comply. But again, this just speaks to the vague nature of the mandate. It's not clear. And folks aren't clear in the approaches they need to take. It's a little bit of many of these things. There's no single approach. There's no single technology that's going to be a GDPR compliance technology. Just some other interesting numbers. About 20% haven't started doing anything as it relates to GDPR. And these companies that we polled, these weren't small companies. These are the multinationals that we at Guidance Software, now OpenText, do business with. And that's concerning. The fact that some think they can just divest operations, I think, is a little short-sighted and certainly isn't aligned with elements of growing a business, maintaining a business, or anything, particularly reasonable. It seems, again, to be folks that are just going to try to avoid it until they have to. And that's going to happen. There's going to be a wait-and-see mentality to some degree with some organizations, going back to who's going to be the first to find. Is someone going to be fined? And when they do, okay, now maybe we'll see some organizations start to take this a little bit more seriously. It's Groundhog Day with PCI compliance. It's funny how we kind of don't learn from the past and continue to approach, in this case, new regulations much in the same way as we've approached previous ones, which, again, if you look at PCI today, that's a far more mature from a compliance perspective. There's a whole cottage industry that's grown up around PCI that's alive and well and serving businesses around the globe to that regard. Small, medium businesses, those are going to be the slowest to start, and I think that's where there's an opportunity for service providers to provide either some consulting or even try to manage some of the risks by taking ownership of some of the requirements for their clients. Now, I think this only applies, again, to businesses that are over 500 employees. And by saying that, the answer to GDPR isn't firing 2 employees so you get down to 499, though I'm sure, based on some of these responses, somebody's thought of that. It's the larger companies that are really starting to take this seriously. And again, like I mentioned earlier, I'm seeing the most maturity along the process with your JP Morgans, Wells Fargos, banks like this that have a little bit more to lose, and certainly can't really divest European operations or do other things to remove their business from that area. Quarter haven't begun even looking at products, though. Again, looking at GDPR, I think it's less about products and more about process. Though, as we're here at an e-discovery conference, we'll be talking a little bit about how we should be thinking about our e-discovery technology, particularly from an architectural perspective, in terms of ensuring compliance with the mandate. So in terms of processes that folks have currently to identify citizens, again, looking mostly towards the European organizations we polled, there are current processes that can identify data records, determine where that data is being processed. If you look particularly at, again, the financials, credit card companies, they have pretty well-established fraud monitoring type systems in place, which can be used to some degree to help understand what and where information's getting processed. Some are in the testing phase, but again, more than half have not even begun to consider what they might need to change or do, other than the obvious: we need a data protection officer to begin down the path of ensuring compliance and the ability to audit against that compliance, data location, data movement, data owners, et cetera. So before I move on, any questions on some of the research that was presented? Comments, thoughts? All right. Yeah. That's one of the things that's necessary. At least segregating it so it remains in country, or establishing frameworks that allow an external party, maybe external to the country, to monitor status, but not necessarily be able to look at content or look at the actual data that's located within the country. But data segmentation is going to be an important part. And I think that's going to end up being the trickiest part, in that not just has process implications, but technology and architecture implications as well, and I'll get into that in a little bit through the talk. So a few things to start thinking about as you may be preparing your own or your client's ability to prepare for GDPR. First, as a few in the room have done, just read the GDPR and understand what the potential impact is based on your interpretation of the regulation. Conduct an internal audit against areas where there is data handling, sensitive data handling, PII handling. This is not just a technology audit, but who should have the data? Who should be using the data? Why are they using that data? Do they have methods to securely store and remove that information? This is kind of known as the data owner as it pertains to any element of information within your business that falls under the regulation. Now, we're talking a lot about data handling, but the regulation also calls for a security incident response program. And compared to the kind of mean as it exists against the U.S. breach response requirements, which I think across maybe 48 states have implemented a breach response regulation or law. Most of them call on average for a 30-day response time. GDPR is calling for a 3-day response time. And it's calling for not just an acknowledgement of a breach, but as much information as can be presented about what data was affected, how was it affected, what was the impact of that particular breach. Now, reasonable or unreasonable, that's the letter of the law as it exists today. Will that remain in place? We'll see. If you look at the breaches that have been reported in the U.S., Equifax, great example, not 72 hours, not 20, 30 days, even in terms of a good response. So the requirement of 72 hours, I think, is a little unreasonable. It's a great goal. We should be able to at least have systems in place that can detect and prioritize clear and present threats to sensitive data in a short period of time. But again, the news and breaches that have been going on recently show that we're still quite a ways away from being able to do that. Gaps in technology, another obvious one. There's a few provisions where there are clear technological requirements, being able to identify information, okay. Being able to remediate, remove, delete information, that could be a technology gap. But again, most of the requirement is really around how to think about data and how to, suggestions on how you should think about architecting your systems to ensure data segregation, cross-border, and again, abilities to ensure that that information can be audited and that parties outside country are unable to view sensitive information that belongs to in-country citizen. And it's not a one-stop process either. Just like PCI, as you're rolling out your plans, that should also include a regular time frame to re-audit, reassess, and ensure that things are operating as you would expect them to, and no additional gaps or pitfalls are identified through that initial rollout. Again, just like we approach PCI. And the obvious, appointing a data officer. Those that are responsible or in an organization that's compliant, who has appointed a DPO at this point? We got one. So that's roughly 2% has appointed a DPO at this point. And that's, the first step. You need someone to help coordinate all this. There's no one within the organization that has a clear mandate, at least at first blush, to take responsibility over some of the elements within this. Risk compliance, sure, but this goes beyond that into people, processes, technology that fall a little bit outside kind of the typical risk and compliance officer's mandate. In the meantime, you should ideally have someone in charge of security within your organization or a risk officer who can start kind of bringing together the stakeholders, having these conversations, looking to appoint data officers, conduct audits, whatever have you. In the real world, this isn't going to be a single person. HR is involved, IT is involved, legal, risk, business owners. this is pretty far-reaching as it pertains to your business. Heck, this is going to reach into your marketing departments who are doing email campaigns to European citizens, as another example. I don't know anywhere within an organization where you may not find PII related to customers, partners, et cetera. And in this case, those citizens of the European Union. So let's look at some of the specific requirements for which there are processes, technologies that can start to be looked at in order to bring us a little bit closer to compliance. So looking at a few of the articles, one, and this, if we're already PCI compliant, the first is something where presumably there's some systems in place to help with. Can't keep that data for any longer than is necessary for which the data requires to be processed. This is just like PCI. You can't keep credit card data, or shouldn't keep it, for any longer than has reasonable business usage for your firm. So too with the GDPR. What does this mean? You need to have an ability to remove, to remediate that information once it's past some sort of retention or policy that's set in place against it. So while, again, GDPR doesn't say create a records retention policy for European citizen data, that's really an interpretation of this first provision. As well, and this is going to be interesting to see how this strains the system, European citizen at any time has the right to request information about any data you might have. And when you start thinking about some of the bigger players in the space, your Googles, Facebooks, Amazon, whatever have you, that could be pretty far-reaching, could be pretty extensive in terms of where and what that data is. For others, it'll be a little bit more manageable, but to give you an idea of the scope of the issue as it pertains to some of the larger technology companies out there. What does that mean? You need to have systems not just to identify their data as it might exist in a payment processing database or whatever have you, but this is Excel sheets out in your finance team. This is unstructured data. This is data out in Box, Dropbox, potentially, if there aren't already policies in place to at least attempt to prevent the movement of data out in the cloud repositories, or the movement of sensitive data, that is to say, out to cloud repositories. And they have a right to obtain that data, not just to understand what it is and where it is, but give me my data. Thus, the needs to collect, preserve, and package up in a way that you can reasonably share that with those citizens is going to be required. And again, that's not a single technology. That reaches across all areas of the business, everything from the Oracle database to the laptop sitting on the email marketing manager's desk. So how are we going to consider that? How are we going to ensure that we're able to reach into all of these repositories in kind of an agnostic way with a scalable search function that will be able to present this information in a way we have confidence? This isn't much different than what we do for e-discovery, though the scale is far different, more akin to things like FOIA requests in the government. But even that is data that's more easily defined within systems than the name, a phone number, an address, whatever have you, related to PII. Talked a little bit about the incident response requirement. This is the letter of the law. Was that a hand? Yeah. There's all sorts of places the information could be. And to that point too, where it will be interesting is there will absolutely be litigators arguing against the reasonable nature to produce some of this information in some cases. I can't remember the details. There was already some litigators arguing against some of the requirements of GDPR a few months ago. I think it was, I presume it was Google. But nonetheless, we're going to see arguments on day one. We're going to see pushback on day one. And that, to your point, in some cases, there isn't technology that's going to help remotely identify this information, particularly when you think of backup tapes and things like this that you may have in the organization. So where's the line? Yeah. And that's where, the arguments are going to come to bear. And will it get amended? Perhaps. I mean, we're on what revision of PCI at this point, as learnings have been applied to some of the earlier interpretations and writings in PCI. But like I said earlier in the talk, the regulation is written in a very fuzzy way. And that's going to, I think, really open the door for arguments against interpretation. And we'll see how precedent gets set when those first requests start coming through after May. And finally, it's in great detail. Back to how precise it is. The categories, the approximate number of data subjects concerned, categories, appropriate number of personal data records concerned with a breach. This is way beyond just saying, I had a server hit. The EU is going to want to know in detail what was hit. If this was Equifax in a year, there's no way. They'd be in violation immediately. They still haven't been extremely forthcoming with the extent of that particular breach. Even Yahoo. At first, it was this many million records. A month later, it was this many plus this many records. And it's been growing as that investigation has continued. So again, what's reasonable? Is trying reasonable, or is successfully fulfilling the letter of the regulation what's going to be needed? And it's going to be somewhere in between, at least initially. So again, you need to answer, where's the PII located? Why is it stored? How is it used? How long is it kept? Applying retention rules against some of this information in different ways. Does everyone know their role in the event of a breach? I couldn't tell you, time and time again, you see the first time a company practices their breach response plan is when they're breached. That's too late. This is something that should be planned in advance. Tabletop exercises conducted. All parties, legal, HR, security, executives, PR, should be involved and know what their job is. Again, according to the regulation, you got 72 hours. There's not a lot of room for error, approvals, editing notifications, et cetera, in a 72-hour time frame, even if everybody stays awake 24 hours a day in order to answer some of these questions. So I think the first place to look is the information governance framework. It's, again, not a perfect map into GDPR, but it starts to provide a little bit more solid advice, solid direction in terms of how to architect a broader IG program that encompasses some of the requirements of the General Data Protection Rule. And this is a broad industry, a broad market, if you will, IG. It's emerging. Even that hasn't been quite defined. I think the information governance reference model was appended onto the EDRM 3 or 4 years ago. And it certainly starts to bring some clarity in terms of how to think about managing data. It's not entirely prescriptive, but for lack of anything better, it's certainly a good place to start. Technology might be developing a lot faster than the creation of your own policies, DLP, endpoint controls, encryption. These things are advancing quick. Technology you're looking at today is going to be different in a year by the time GDPR is in place. But again, something is better than nothing, and I suspect, at least initially, showing a reasonable effort to try is going to be what the EU really wants to see on day one. Not, we haven't thought about it, we haven't done anything, we don't have a data protection officer. Some progress will be needed. And those external stakeholders are going to have their own expectations versus you and your internal stakeholders. So this is just, if you aren't familiar with the IG reference model, this follows the creation, everything from creation to how it's stored, secured, archived, through the disposal of information mapped to the different business units who are primarily responsible for that particular function. What's not in the diagram, though it could benefit from, is in some cases two-way arrows, in that if I think about between IT and business, now under GDPR, IT may have access to the tools and technologies to ask questions, but they're not going to have the right to look at the information. They're going to have to, and you're going to have to figure out new ways to escalate results of audits to in-country data owners in order to review, make decisions, and push those decisions out into the environment. In terms of storage and security, can hopefully everybody encrypt sensitive information, is using encrypted traffic. There's some basics as it relates to security that should be in place that are going to be easy wins in terms of showing some reasonable effort to comply or ensure that you're covered in some areas. And those should be looked at sooner than later. There's also something we worked on internal to guidance. What does IG maturity look like? Where does it start? I think this is an opportunity for everyone in the room, at least those of us that are on the legal side of the house, to start the conversation. As inside counsel, for those that are, what's the job? The job is managing risk. This is all about risk to the business. Legal is a key stakeholder and will be a key stakeholder amongst the teams responsible for ensuring that there is processes in place, ongoing audits in place, the ability to report in place, and ensure that your company isn't going to be the first to fall under some heavy fine, either from a data breach or an inability to comply to the requests of European citizens. So the opportunity is bring in those stakeholders, talk to HR, talk to InfoSec, talk to risk, compliance, pull together those teams, start talking about it. Where are the gaps? Who should be responsible for what? What type of data is sensitive, and how's that used? Now, when it gets to the point where technology gets procured, processes start to change, or at least are, what's the word I'm looking for, suggested to change, you're going to need C-level buy-in. Your ability to do anything is going to be greatly diminished if the CEO's not on board, if the board isn't on board with the program, in that, you're going to need very quick approvals, or want very quick approvals, to move against whatever you believe are the right things to do in order to ensure your business is protected against these requirements. And eventually, third-party consultants will be part of that steering committee, partners, suppliers, et cetera. Doing business doesn't mean this data just stays in-house. It gets shared with others that you do business with. What kind of controls do they have in place? What kind of contracts do you have in place with those suppliers to ensure that they're treating your data appropriately? And this is also where it gets interesting, in that, going back to what I said earlier, that companies under 500 employees, well, they don't need to follow the regulation. But what about that company of 15,000 that does business with a company of under 500 employees? You bet that affects the larger company. And some controls and agreements need to be in place between that company and their smaller partner or supplier to ensure, as soon as it doesn't get over there, that it's out in the wild and open to whatever risks, threats, hacks, insiders that could exist in that company, even if it's just a legal contract that puts some presumption of risk on that particular partner. Or something I've seen as well is ensuring some minimal degree of security controls in place in areas where data that's belonging to your business or citizens is used or housed by that third party. So looking at some kind of key requirements here, again, trying to start small, in that if you try to tackle this whole thing in one fell swoop, it is overwhelming. And again, it's open to too much interpretation as a whole. Some of the basic things you should have in place is an ability to identify sensitive and aged data, both in unstructured data land, in data repositories, in the cloud, wherever you and your employees have access to store information. It would help to have some categorization in place in order to quickly understand where and what this data is when you will be called upon to produce or report on that data, or even your ability to report on that data. And of course, remediation capabilities, the ability to wipe securely any citizen PII that's requesting that you do just that and prove through record that you have taken those steps, and could potentially even prove to the regulator through an audit trail or whatever have you that those steps did take place, the citizen was informed, and you're in compliance with that letter of the law. So going through each of these areas, first, identification. Something a little system agnostic will help. It will be far more difficult to implement 15 different technologies to address the 15 types of storage repositories, unstructured, cloud, Amazon, virtual machines, whatever have you, that you may have. And this, hearkening back to the e-discovery problem, similar, but at a completely different scale in terms of not, this isn't 100 custodians, this is my entire estate, 10,000, 20,000, 100,000 machines that could be out there. Ideally, I can take a single search criteria and apply that agnostically across most of my systems. 80% would be great, covering the balance with potentially other technology, and that I'm thinking about things like SAP and Oracle, which may have their own built-in capabilities to audit, report, and remove information. It's all the unstructured and semi-structured that I think is going to be the biggest challenge. Visibility is going to be important too. What if that data is deleted but not wiped? It's still there. It's still a risk. What if that information is encrypted or locked or in use? This is another challenge that we're familiar with in e-discovery. If I'm on my laptop and I've got that one spreadsheet of PII open and I'm working in it, a remote technology is going to be blind to the fact that that file exists on my system until I close it and move on to something else. So thinking about technologies that are able to see in-use data, encrypted data, et cetera, is just as important as data types and data location. Going to need to be pretty flexible too. I'm going to be interested to see just the sheer number of false positives that are going to come out of some of these PII scans. Unlike credit card data, which is a little bit more predictable, there's algorithms that can validate the numbers within a credit card. That doesn't exist for government ID numbers. That doesn't exist for addresses and names. How are we going to create these fine-tuned expressions that are going to be able to pull this information back in a responsive and confident manner? Categorization. Some vendors are already producing the ability to categorize some things that are out of the box, but we're not talking about out-of-the-box data again. It's going to be more, I think the approach is going to be more about good search criteria, the ability to tune false positives, and then apply categorizations to the results rather than attempt to leverage automated classification technologies for this type of information. Again, credit card type information, different story. But when you're talking about names, addresses, phone numbers, IP addresses related to the machines that citizen may be associated with, it's going to be a lot more challenging. And finally, remediation, which may be, will be just as challenging as some of these other areas. But the good news is If you have the ability to find it and categorize it, remediation's the easy part. You already know where it is, you already know what it is. That's the hard part in this equation. But following on that, you are required to have and prove the ability to remove that information. And that's not the delete key on Windows. That's a more, just a more, a deeper wipe of information. If a bad guy or insider can find that information, it's still exposed. And again, hitting the delete key on Windows, that data's not gone. I can go into my deleted folder and get that information. Even if I remove it from my deleted folder, that data still exists on that endpoint. And while your employees may not be able to find it, the bad guys can find it. They know where to look. They know where things hide. And that's not going to completely remove the risk that that information could be produced at some future point and leveraged against your ability to have proven or maybe not have proven compliance with the wipe request that was sent over. Also tricky architectural considerations. This isn't just about, again, a single technology. Any technology that you use, any technology that you pull into your environment, now you have to think about how it's transmitting data across your global network. Is it transmitting data across the global network? What data gets transmitted? Are there protections and agreements in place that allow for that movement in data? In some cases, there won't be. So we now need to think about architecting systems where, excuse me, scans, reviews, storage is all done in country and ensure we can prove that that data segregation exists. I've had a number of conversations again with some of our European clients. We have an offering that is focused on unstructured data, EnCase, one of our EnCase technologies that allow you to create criteria, look for sensitive data. We take it all the way down to the content level. So as I'm doing a demo, I remember just last week I was in France showing this to a customer. Isn't this great? You can look at a map of the world. You can see where sensitive information exists. You can click in and now see machines that have what kind of sensitive data. Okay, they're following along. And now if you click again, you can see the content. Isn't that great? Whoa, no, that's not great at all, they said. We can't allow just anybody to look at this data. I can't have my operator in New York or my operator in the UK look at these names and addresses of French citizens. I need a way to allow them maybe to understand that there is data here, but I also need a path to escalate that to an in-country data owner to do a review, to make a decision, to update the technology on the decision that was made, and move on with the process. This is going to be more interesting when you consider on the security side things like packet capture technology, anything that's looking into network traffic as it moves across the world. There is likely sensitive data in there that no one's really thinking about or looking at now. Now, that's not going to be the first problem. The things that I'm talking about today, I think, are the steps to get started. But eventually, we're going to find the problem is even more complicated than it looks on face value. And that's where we'll see arguments against the regulation. We'll see reinterpretations. We'll see revisions. And hopefully something a little bit more realistic to implement as multinationals or any kind of business that does handle European citizen data. So really, if you haven't already started planning, hopefully through this talk, you've gotten a good impression that now is the time, even if it's just to say in May of 2018 that we've started to take an approach to compliance. Maybe not compliant on day one, but if you're not compliant and haven't even started thinking about it, you're going to be worse off than those who can at least say, hey, come back in 6 months, we're rolling out this plan, we have a time frame, and we've got all of our stakeholders bought in on what it is we need to do. Problem's not going to be going away. There's going to be more hacks, more breaches, starting to talk particularly in the security world, on how IoT affects all this. That's a whole new host of PII that's getting introduced into systems and databases and whatever have you. Where's that stored? How's it stored? There's less control of this information as new technology gets adopted. There'll always be vulnerabilities in technology that attackers, insiders will be looking to take advantage of. And really, despite the need or despite the letter of GDPR, being able to implement some of these things, knowing where data is, how it's used, who should be using it, retention policies, this is just good IG practices. And again, starting with a information governance approach may allow you to more reasonably put this into bite-sized chunks and start rolling out different processes and technology that address some of these things as it relates to GDPR. So at this point, any questions, comments, thoughts? Yeah. So my interpretation is it's more on their citizenship status, less on where they are. I was in Europe last week. That didn't mean I was suddenly under the purview of GDPR. If I changed my citizenship status, I would absolutely be under the GDPR. But again, someone may interpret differently. I think that's a more reasonable way to interpret it, a cleaner way to do so. And again, at least according to the GDPR, it's not residency, it's your citizenship status. Any other thoughts, questions? Any best practices anyone in the audience has started to implement that you might want to share with some of your peers in the room? I haven't started thinking about it yet. Let's start get cracking. All right, well, thank you for your time. I hope this was informative and gave you something to think about if you have